We are going to analyze a standard criminal law problem question. In this scenario, a pub altercation escalates quickly. Valerie lunges with a weapon, PC Gore steps in to intervene, and a bystander named Poppy strikes the officer to help her friend Samrita escape. In a matter of seconds, 3 distinct injuries occur simultaneously: a deep facial cut, a fractured skull, and severe psychiatric trauma. The Crown Prosecution Service cannot simply charge everyone with fighting. They must legally untangle this physical chaos into unassailable individual criminal charges. Assault is not a single crime. It is a generic term referring to a sliding scale of specific related statutory offenses. Criminal liability on this scale is determined by plotting 2 intersecting axes. The x-axis measures the objective severity of the harm caused, the Actus Reus. The y-axis measures the defendant's specific foresight or desire, the mens rea. These acts are governed primarily by 2 pieces of legislation: the Criminal Justice Act 1988 and the Offences Against the Person Act 1861. Mastering this hierarchy is the difference between failing an exam and securing top marks. You must correctly match the specific physical action and mental state to the exact rung on the statutory ladder. We start at the foundation of the legal ladder. Before any physical contact occurs in our pub diorama, the initial threat of violence triggers criminal liability. This flowchart isolates simple assault. The Actus Reus is causing the victim to apprehend immediate, unlawful personal force. As the bottom left text boxes clarify, no physical contact, violence, or actual injury is required. The crime is the apprehension itself. The parameters of this apprehension were tested in the 1997 case of R.V. Ireland, which posed a specific legal issue. Can a series of silent telephone calls constitute an assault? The House of Lords ruled that they can. Words, or even silence, satisfy the Actus Reus if they instill a psychological fear of an imminent attack. If simple assault is the fear of force, physical assault, often referred to as battery, is the application of it. Its Actus Reus relies on a different legal verb: the actual infliction of unlawful personal force. The required force for a battery can be incredibly slight. A gentle push, a prod with a finger, or deliberately throwing an object completely satisfies the legal requirement. The mens rea for both of these common law assaults requires either intention or subjective recklessness. The defendant must foresee the risk of causing the apprehension or the infliction of force, and go on to take that risk. Lay people frequently use the word assault to mean a physical beating. Legally, the distinction is exact. Simple assault is the fear. Physical assault is the touch. Let's advance our pub diorama to the first escalation of harm. A strike connects with a victim, resulting in a visible black eye. We have now moved past the common law and into Section 47 of the Offences Against the Person Act 1861, assault occasioning actual bodily harm. On the Section 47 flowchart, the Actus Reus for actual bodily harm is specific. Established in R.V. Miller, the injury must interfere with the victim's health or comfort. It must be more than transient or trifling and can include psychiatric harm. This introduces constructive liability. This is the exact conceptual trap where law students most frequently misapply the law in exams. The confusion centers on the required mental state. The 1991 case R.V. Savage deconstructed this. The defendant intended to throw a pint of beer over the victim, but the glass slipped, breaking and cutting the victim's wrist. The Lords ruled that for a Section 47 charge, the defendant does not need to intend or even foresee the actual bodily harm that results. Notice the explicit note in the mens rea section of the chart. The mens rea is satisfied completely by intending or being subjectively reckless as to the underlying simple or physical assault. If a defendant intends only a minor battery, like throwing a drink, but accidentally causes a severe cut, they are strictly liable for the resulting actual bodily harm. The law severs the requirement for intent to match the final result. Returning to the pub diorama, we examine the most severe injuries. Poppy strikes PC Gore, causing a cut to his face, and Valerie lunges with a kitchen knife. These actions trigger the top tiers of the statutory ladder, Sections 20 and 18 of the 1861 Act, governing wounding and grievous bodily harm. The Section 20 flowchart defines the Actus Reus parameters clearly. Based on the precedent of Moriarty v. Brooks, A legal wound requires the cutting of both layers of the skin. A critical point for exams, under the ruling in JJC v. Eisenhower, internal bleeding or heavy bruising is never legally a wound, regardless of how severe the internal damage is. If the skin isn't broken, the prosecution must prove grievous bodily harm. Referencing the alternate branch of the chart, DPP v. Smith establishes this threshold simply as really serious harm, such as a fractured skull. Both Section 20 and Section 18 share the exact same Actus Reus. The difference in charging relies entirely on contrasting their specific mens rea requirements. Section 20 requires the defendant to act maliciously. In criminal law, following R. v. Cunningham, malice has a specific definition, intending or being subjectively reckless to as to causing some bodily harm. Section 18 is an indictable-only offense carrying a maximum life sentence. As the flowchart dictates, it demands a specific intent to cause grievous bodily harm. Mere recklessness is insufficient here. However, Section 18 has an alternative mens rea track. If the prosecution proves the defendant intended to resist or prevent a lawful apprehension while recklessly causing harm, the police officer victim variation, the charge upgrades to Section 18. The difference between a 5-year sentence under Section 20 and life imprisonment under Section 18 almost entirely hinges on proving exactly what was inside the defendant's mind at the millisecond of the attack. We can now apply this statutory framework to resolve the problem question of our pub altercation. Valerie lunged with a knife, causing a deep cut. Because she intended to cause really serious harm and achieved it, she satisfies both the Actus Reus and mens rea for a Section 18 charge. Poppy struck an officer to help her friend escape. Because her intent was to resist an arrest while causing a cut to PC Gore, she triggers the alternative Section 18 resisting arrest charge. Let's consider a hypothetical variation. A defendant foresees only a minor push, but the victim falls and fractures their skull. Even with the severe Actus Reus of grievous bodily harm, this action falls strictly under Section 20. The defendant's mens rea was merely recklessness as to some harm, not a specific intent to cause GBH. This matrix, Table 4.1, serves as your master blueprint. It clearly details the intersections of Actus Reus and mens rea required for every level of assault. There is one final legal caveat that can completely absolve a defendant of liability for physical assault: the defense of consent. For consent to be legally valid, the victim must understand two things: the nature and quality of the act and the true identity of the defendant. The boundaries of this defense were defined in R. v. Dika. The court ruled that consenting to sexual intercourse does not equate to consenting to the risk of HIV infection. Concealing the disease vitiates the consent entirely. Mastering non-fatal offenses requires clinical precision. You must separate what the defendant actually caused from what they intended, mapping the facts strictly against the statutory matrix of Actus Reus and mens rea.